Next up, let's look at contracts and restraint of trade. Strictly speaking, these types of contracts are not illegal, but they are void. There's three main types of contract that may be in restraint of trade. First, contracts of employment. So for instance, an employment contract may state that where an employee leaves the employment, he or she may not be employed elsewhere within a certain period of time. That would be a restraint of trade. Second, contracts for sale of business. Sometimes when parties buy or sell a business, they stipulate certain restraints as part of the contract. So for instance, if a hairdresser sells their business, the buyer may want to make sure that the seller does not open another hair salon right next door or even within the wider neighborhood. So certain rules apply again, as these are contracts in restraint of trade. Third, solace agreements are also contracts in restraint of trade. These are agreements where one party promises only to sell the other party's products, for instance. These three types of contracts, employment, sale of business, and solace agreements, may be in restraint of trade. However, that does not mean that they are necessarily void. Their validity is determined by reference to three main issues. First of all, it has to be shown that the restraint is a legitimate one. There's basically only two types of legitimate restraints: trade secrets and business connections. What this means is that a party to an agreement may legitimately restrain the other in relation to trade secrets. That means that the other may not divulge such trade secrets in any future employment. Similarly, a party to an agreement may legitimately restrain the other party from using business connections which the other party acquired in the course of employment in any future employment. However, even in respect of these two legitimate restraints, there's two other criteria we need to look at. Even if a restraint is legitimate, it may not be reasonable if it lasts for a very long time. Therefore, the second criteria that we look at is length of time. How long is the restraint relative? Sometimes, even a year or two may be too long. As we will see when we look at some examples, sometimes a very long period of time, even a lifetime, may not be too long. It all really depends on the circumstances of each case. The third criteria that we look at is the extent of the geographical area covered by the restraint. So, for instance, in the example of the sale of business of a hairdressing salon, if there's a restraint stopping the seller from opening another salon, that restraint may be unreasonable if it is meant to be applied across the whole world, or even across an entire country. However, if the restraint is limited to a particular locality or a particular part of town, it may be reasonable. So what we need to do is we need to look at all three criteria in order to assess whether a restraint of trade is valid or whether it has voided the contract. Let's now move on and look at some of the details relating to these three criteria. Starting with the first one, whether the restraint serves a legitimate purpose. In Home Counties Dairies and Skilton, the issue was that a milkman was restrained from dealing with people on his milk route, the people he was selling milk and cheese to, as part of new employment. The court held that this kind of restraint serves a legitimate purpose and is reasonable. In Littlewood's organization in Harris, a member of staff in a mail order firm was restrained by a wide-ranging restraint of trade clause. The court held that the only reasonable restraint was in relation to the actual mail order business. That means once that staff left his employment and started working for a rival company, he could only be restrained in relation to the types of activities that he carried out for the previous employer. In Foster & Sons and Suggett, it was held that glassblowing constituted a trade secret. That is because it involves specialized skills as well as specialized knowledge in terms of the heat, the amount of air, and other factors that are necessary in order to perfect the art of glassblowing. However, not all knowledge that is acquired on the job can be subjected to a restraint of trade clause. In Facenda, Chicken and Fowler, the defendant, as part of his duties on the job, had acquired a lot of knowledge and expertise in relation to selling chicken. However, this was not deemed to be a trade secret, so when Mr. Fowler started employment elsewhere, he was free to use that knowledge and expertise which he had acquired at the previous employer for his new job. As you can see, it's not always obvious what is or is not a legitimate purpose. We have to apply the cases that we've learned about as well as common sense in making the correct determination. Once we've determined that there's legitimate interest to be protected, we also have to make sure that the restraint imposed is a reasonable one. That means that the restraint only goes so far as to protect the legitimate interest and no further. This is done by looking at the length of time in which the restraint applies, as well as the geographic area for which it applies. Let us start with the length of time. In Home Counties Dairies and Skilton, this was the case of the milkman who had been restrained from dealing with his old customers on his own milk route for 1 year. This was deemed to be reasonable. Incidentally, in Littlewoods and Harris, the restraint was also for 1 year, and this was reasonable. Esso and Harper's concerned a solace agreement. Recall, this is the type of agreement where the buyer is bound to buy only from one source, to seek his supplies only from one source. So in this case, Harper's was to seek his supplies only from Esso, and he was supposed to do so for 5 years. This was deemed to be reasonable. Thus we see that in relation to solace agreements, the restraint may be longer than in relation to employment agreements. But of course this makes perfect sense. Whether a person can go and seek employment elsewhere is very important to that person's livelihood. So a restraint which is overly long may be unreasonable. However, when we speak about solace agreements, the parties freely get together and agree such contracts and such restrictions. In this case, Esso made an investment and Harper's promised to buy petrol only from Esso for 5 years, and this was reasonable. There was another agreement in Esso and Harper's which was for 21 years. This was deemed to be unreasonable. Is there a magic answer? Is there a magic number of years? Probably not, but we know that 5 years is reasonable, 21 years is unreasonable in relation to these types of solace agreements. A bit of an outlier is the case of Nordenfeld and Maxim Nordenfeld. This is because the restraint in this case was to last for 25 years, and the court held that this was reasonable. But this was really determined by the circumstances and the facts of the case. Nordenfeld was an expert at making guns and ammunition, and these were unique. He sold his company to Maxim for a very large amount of money. Part of what he promised was that he would not engage in making such guns and ammunitions for 25 years. The reason why such a long span of time was deemed to be reasonable was due to the high level of expertise that went into making these guns and this ammunition. It was a very rare and specialized skill. Of course, the amount of compensation, which was very high, also played a role in the court's decision. There was another proviso in Nordenfelt, namely that Nordenfelt was restricted from going into any form of competition with Maxim. This part of the agreement was held to be unreasonable. So the court said that the part of the agreement which stated that Nordenfelt was restricted and could not manufacture the specialized guns and ammunition, that was reasonable. But the more general clause, which restricted him from engaging in any form of competition, that was unreasonable. We'll get back to this point when we talk about severance in relation to remedies. But first, let us also talk about Fitch and dues. This case involved a solicitor's firm, which was managed by a managing clerk. The clerk's contract stated that once he left the employment, he could not work within a certain radius, and we'll come back to this point because it relates to geography, for potentially the rest of his life. The court held that this was reasonable given the business or the type of business at issue, which is a business where clients are likely to return for a very long period of time. In other words, if you are with a particular solicitor, you may not go and have business for that solicitor all the time, but whenever you do, you're likely to go back to that solicitor. So it was reasonable to extend the restraint for such a long time. Now, of course, we have to see this in light of the geographical issue as well. It did not mean that this managing clerk could not work in any solicitor's firm at all. It just meant that he was restrained from working in a solicitor's firm within a certain radius. Which brings us to the next issue, the third criteria, which is the geographic extent of the restraint. So coming back to Fitch and dues, here the geographic extent was 7 miles, and this radius was okay because it was within the catchment area for solicitors. So here we really have to look at both the length of time, which was potentially a lifetime, as well as the radius. That means the managing clerk was of course able to work in another solicitor's firm, it just had to be outside of this radius. Now note that this case happened in 1921. Now with improved transport, the radius would likely have grown by now if we had a similar case in 2015. That is because improved transport has also increased the catchment area, which basically means how long would you travel for to see your solicitor. Now in the past, it might have taken a long time to travel those 7 miles, perhaps half an hour or so. Nowadays, in that half an hour, you could probably travel for 50 miles or more. So we have to see these things in the context of what's possible in terms of transport and how long it takes to get somewhere. Generally, we look at the catchment area. In Goldso and Goldman, a jewelry business had been sold, and the buyer restrained the seller from dealing with real or imitation jewelry both at home and abroad. In fact, there was a long list of countries included as part of the restraint. However, the seller of the business had only ever dealt with sales locally. This means in the United Kingdom. He had never sold his jewelry abroad. Thus, the court held that the restraint of trade that extended to selling overseas was too wide. The court narrowed the restriction to in the UK only. Lastly, in Maxim Nordenfelt, the restraint was worldwide. Recall, this was the case of Mr. Nordenfelt, who was a specialist at making guns and ammunition, very specialized guns and ammunition, and he sold his business for a lot of money. He was prevented from making those guns and ammunition for 25 years. That part was reasonable, as well as the fact that the restraint applied worldwide, again, because of the level of expertise which was so specialized.